medical.
All right, okay, we'll hear it.
Gonna have that.
Okay, good morning, everyone. We will go ahead and call the recommending committee meeting to order for the Las Vegas City Council, September 4th, 10 a.m. Item number 1 is called to order. We just did that. Item number 2, we're in compliance with the open meeting law.
Yes, we are.
Thank you. All right, we will go to item number 3, which is an abeyance item, Bill 2018-20 for possible action amends LVMC 6.95.
Councilman, we're going to pull item 4 forward. We're going to pull.
Okay, possible action amends 6.95.090 to limit the availability of business licenses for retail marijuana stores to those that will be operated in conjunction with a medical marijuana dispensary at the same location with the same ownership. That is sponsored by Councilman Coffin. So I guess we'll start with staff. Do you guys want to make any comments on that?
The attorney here is going to make an initial presentation, and staff can fill in where I have made an error. You have before you a proposed First Amendment. It changes the title and the summary to reflect what's in the proposed First Amendment. I'm not going to read those for you, but what it does is it basically says the default is that you can only get a new retail marijuana store license if in conjunction with a medical marijuana dispensary under the same ownership, but if there are no new medical marijuana state licenses available, then you can go ahead and operate a retail operation by itself, but you have to follow the guidelines that are set forth in, it's on page 7 of your proposed First Amendment. It talks about how the store must be designed so product is not visible to persons outside the store. Priority service has to be given to holders of valid registry identification cards. The store must offer for sale marijuana products that contain high levels of cannabidiol, and the store must provide educational information to customers upon request regarding the different types of marijuana and marijuana products and their purported medical effects. There are also some cleanup provisions that we missed the last time, where we're simply adding to the retail stores the kinds of regulations that previously applied to medical marijuana. Do you have any questions about that? Yeah, I can answer those, or staff can answer those.
Okay. All right. I guess we'll go to public comment, and let's hear from the public on this, and then we'll have a discussion up here. So.
Could I explain why the First Amendment, and that way people can judge?
Sure. Okay. Let's have Councilman Coffin explain the First Amendment.
I'll explain why there is a First Amendment from the original draft, although there might have even been 2 original drafts. When I requested this bill draft 8 or 9 months ago, I did not know that the state was going to not issue any medical marijuana cards anymore. My feeling has been all along that medical was the most important thing. That's the reason it passed. It is the reason there is a medical necessity for it, and I think you all know I use it for medical purposes. But then finding out there were no medical licenses being issued by the state a few months later, this bill would have essentially stopped all new retail. So I was willing to certainly put that in front of the council, and it is still in front of the council, that issue. It should be no matter what you see here, the idea is still in front of the council. The question is, though, that I found out that a major licensee, somebody who has really invested a lot of money and has a good name in town, actually needs one of those new recreational licenses. There's a twist and turn involved in this that the city attorney can explain. I discussed it with Brad, but I don't know, Brian, if you're aware of the acres problem, because we don't want to just cut somebody out of business, which the original bill would do, apparently. That's what I was told. So if somebody could explain the need for the amendments, the need, frankly, for us to approve recreational, but at the same time, obviously, you see these amendments in here, council members, you see that you really have to operate like a medical, even if you have retail. And so that's on page 7, lines 4 down. So if we could have an explanation of why it was impressed upon me that we needed to do this in order to keep a good business in business, or they would shut their doors.
Let me see if I can answer that question, Councilman. The original bill and the proposed First Amendment operate on brand-new applications. So if you have a person who already has a license, this bill in no form ever affected that person. I don't know if that helps, but it only operates prospectively after it's passed. If it's ever passed, anybody who comes forward with a new retail application would have to follow its guidelines.
Well, so if I could ask you then through you, Mr. Chairman, if then in fact, Val, that's true, how did this affect somebody with an old license? If they then, this would only affect new people. Please give me the practical aspect.
It would probably be helpful, Councilman, if maybe the business licensing gave the history of Acres Medical down here. Darcy maybe could give you the history about Acres, if that's okay, Chairman.
Sure.
Good morning. Darcy Edelby Hurd, Business License Section Manager. Yeah, Acres did have the medical marijuana establishment license and was granted the retail operating as dual use. Through lawsuits, they did lose their medical license. The state did rescind the medical, but is now allowing them to operate the retail on its own. Our current ordinance allows them to continue to operate in that fashion because we do have them separated out where you could be medical, or you could be retail, or you could be dually licensed. This proposal to maintain the medical components with the retail components would have affected the original, before the First Amendment, would have affected Acres, saying that, I'm sorry, you can't operate on your own with retail. But the proposed First Amendment does sort of give a carve-out, which now allows them, okay, if the state is not going to give you any new medical licenses, then it's okay to operate on a retail, but you have to operate under these specific conditions.
And I think, Councilman, the basis for the lawsuit was that they were ranked inappropriately by the state, and they won their ranking back, is what had happened.
And yet, why don't they have a retail license now?
They do have a retail-only license currently, and they are operating legally by the state and legally by the city.
They just don't have a medical.
I know that the owners, that was their original intent. It's all about medical with those Mortons and with other interest holders. Val, did you?
Yeah, I must disagree that the original proposal said, notwithstanding anything in this chapter to the contrary, no application for a retail marijuana store may be approved unless. That if Acres already had a license, this ordinance never applied to them, even without a First Amendment.
So
I'm hearing.
So Val, just so I understand this, because I just saw this First Amendment, so any recreational application, if this ordinance passes, they basically have to have two windows. They have to have one for recreation sales and one for medical marijuana sales, correct?
As written, that's correct. However, the proposed First Amendment acknowledges that there may not be any future state medical licenses available, so it says you can operate solely as a retail marijuana store if you meet these conditions. Our ordinances never take away business licenses. You have to understand that. If somebody had said, I want an ordinance to take away Acres business license, we would have told them, you can do that, but you have to have a revocation hearing because they have a license. We don't take away business licenses without due process. So this ordinance never was intended to affect an existing licensee.
Okay, so why, I still don't understand why we need what is the purpose of this ordinance? I haven't gotten that yet. I mean, the way it is today, we're going to get additional recreational marijuana licenses, right? We are going to take those and as a city council decide if we're going to give those out, not give them out, where to put them, the special use permit. So I don't understand the purpose of, what does this ordinance do that is different than what is going to happen anyway?
First Amendment.
Okay, let me go back to the original proposal. The original proposal would have said, in effect, after I'm adopted, anybody who comes forward in the future and asks for retail marijuana cannot have it unless they also have, under the same ownership, medical marijuana.
So I have that.
The proposed First Amendment says, wait a minute, I don't want to be that strict because I recognize that I may not have any new retail licenses because we don't have any new medical. So in order to allow retail by itself, I'm going to allow that, but under the conditions that are on page 7. Does that sound right, Councilman?
Thank you, Mr. Chair, through you to legal. I think maybe it does make more sense now. And I'm not sure if I misunderstood the representations made by the people from Acres, which means, according to our legal opinion here, that you cannot be put out of business. You would still be in the retail business. And you would not be in the medical business until new medical licenses come down from the state. Is that correct, Val? They are not in the medical business. Consequently, there is no medical license coming, we've been told, so therefore they would still be out of the medical business, but they would have the recreational.
Correct.
Okay. I wonder, Mr. Chair, because a lot of this, the reason for the bill and the First Amendment kind of hinges on the representations. I think I believed that they'd be put out of business if the original bill was passed. Doesn't sound like that applies. That was the original to the bill. The only reason, I suppose, then for the First Amendment is to require that medical still be a key component of all marijuana stores, and that naturally they don't have to sell it, but they will have to make it available. They have to provide the inventory. That's the gist of the First Amendment. I don't know how you all feel about it, but it seems like we rode in that horse and we took it to the dance, if you will, and I want to dance with her all the way. And that's why medical is being made a forced component of any new retail licenses. But it sounds like Acres is out of the proposition unless their sharp lawyers are missing, or I am missing, or we're missing some angle that, I don't know if Mark is here or if anybody else from Acres is here. If you don't disagree with, Mr. Chairman, through you, if you don't disagree with our legal advice that you can still stay in business, then tell us.
Okay,
So
well,
we don't know.
okay, so I guess, do you understand the ordinance then? So the way it, if I see this clearly, future recreational businesses have to have a separate medical marijuana section in the city of Las Vegas according to this ordinance. That's what we're voting on. If we don't approve this ordinance, then recreational will just do whatever recreational does. If they want to have medical section, yes. If they don't have to. So that's kind of what we're.
They can't have medical section.
No, they don't have to have medical marijuana. If we don't pass this ordinance, then it's just a recreational shop that's going to open up. They don't have to have medical marijuana.
We're not going to allow any more medical marijuana licenses in the state.
It gets down to policy, I suppose.
So
Maybe there's
Yeah, let's distinguish between having medical marijuana for sale and having a medical marijuana license. We're saying now in the proposed First Amendment, you don't have to have a license because you can't get one if you're new. But if you're going to have retail only, we want you to make some offerings that include medical patients.
Right, but if we do not pass the ordinance at all, then recreation would just open up as recreation. Correct, okay. All right, so if I understand it, hopefully everybody else understands it, so let's go ahead and have public comment. So anybody wanting to comment on this particular ordinance before we continue the discussion and then vote, come on up here one at a time and state your name and your comment.
Thanks for letting us set the stage on that.
Good morning, esteemed council members. My name is Peter Ishak. I'm the current president of the Nevada Growers and Producers Association. We're comprised of several licensed growers and producers in the state of Nevada. I had a speech to prepare, but I just have some questions first. So you're going to allow new recreational licenses, but you want us to dedicate a section for preferential treatment for the medical patients? Is that how it's understood?
That is my understanding, correct.
Okay, so I see a little bit of difficulties with that because the reason medical patients go towards the medical facilities is because they avoid the excise tax. So for us to be able to give them a certain section for medical, it would still be under the recreational prices. They would just be getting to the front of the line. they wouldn't be getting any other preferential treatment, except for maybe the potency levels. But then if they're a recreational store, they're not allowed to adhere to those potency levels because they're not a medical facility. So you're basically giving them recreational product, but just to a medical patient. You're not giving them any other benefits.
Okay,
Does that make sense?
thank you. Any other comments?
I just want to point it out that, our facilities would like to have a chance at these recreational facilities. We spent somewhere up to $20 million in some of our facilities. We employ up to 70 people in some of these facilities, and we feel like we should have a chance to put our name in the hat for these recreational dispensaries.
Okay, thank you.
Thank you.
Peter, how do you spell your name?
Last name Ishak, I-S-H-A-K.
H-A-K.
K.
Peter, you say you represent the growers?
Yes, sir, and producers.
What?
The growers and producers of Nevada.
Do the producers have a problem as opposed to the growers?
Yeah, we all have issues because we all applied for recreational or for dispensary licenses in the beginning, and we didn't get them. But we stood the test of time. We spent the money. We spent a lot of money on utilities, bills, you name it. And for us to kind of be not allowed to apply for these licenses, we just feel is unfair and feel
Well,
like
that's a
we're getting
complaint
punished.
you'd have to make with the state because they're not issuing any.
No, they're issuing it. They're allowing us to apply. But in fact, if this ordinance went in place, we would not be allowed to apply for these licenses.
Yeah. I think, Your Honor, well, why not, Your Honor? I think the idea is that any one of these recreational places can offer the discount that is normally given to medical because there's a lower tax paid on medical. And if this is a question, may I ask a question of legal because this is right on the top of it. Well, all right. So let's say a person sells medical under the circumstances that are outlined in the First Amendment. Do they have to pay the same tax on that sale as they would, or can they pay the lower tax, which consequently allows the customer to pay a lower tax? There's a 10% difference.
I can only refer you to staff on that.
I'm sorry, I missed your question.
The question of Darcy, thank you, is through the chair. The issue is, okay, let's suppose that someone doesn't have a medical license and all these new ones are going to be rec only. If they have this medical, if they conform to the ordinance, if they conform to the First Amendment, or even if they don't, if they cater to a medical customer who has a card and that person buys a product of some kind, do they get the same discount or does that have to be voluntary? Because does the seller have to pay the same tax to us and the state?
Darcy Edelby, Hurd Business Licensing. I believe the state's still going to require at point of sale the 10% excise tax,
Okay,
regardless
so
of who
it's
they
not the
sold it to.
discounted price.
Correct.
Okay, they'd have to eat that 10%.
Correct.
Thank you. Thank you, ma'am. Thank you, Mr. Chair.
All right, thank you. Let's continue on public comment.
Mr. Chairman, council members, Nathan Taylor, 8414 West Farm Road. I represent a cultivator here in the valley, and I'm requesting a hold on this item for many, many reasons, which for time's purposes, I'm not going to get into all of those because I know you guys have a lengthy agenda, but there's a lot of things that aren't understood within the industry. There's a lot of stakeholders that don't understand some of the language. I myself found some language in this bill without getting too technical that I think needs to be tweaked. I think holding this and moving forward with something like this in the future is a good idea, but like Councilman Coffin had mentioned, there's going to be 10 more, I believe, licenses issued here in the city of Las Vegas for retail marijuana. There's also, I've looked into the last few days, some issues related to being vertically integrated. So meaning, of course, obviously like cultivators who may want to get into the retail business, the issues with the taxes that were just brought up with some of these businesses, all the jobs that are affected. My client has 42 employees. So we want something to be passed, but we want it to be right when we do it the first time. So if we could hold this in some type of abeyance, that would be great. Thank you guys very much.
Thank you. Any other public comment? Come on up.
I push the button. Hi.
Hi.
Mark Bradley, CEO Greenleaf Farms. I had a little bit of a prepared statement this morning, but hearing what you said ahead of time, I think I could add a little bit more light to what I think is going on in the industry and maybe help resolve the medical issues and licensing. I originally was here 4 years ago. I applied for a dispensary. I didn't get one the first time around. I'm back again. I have plans for an 18,000 square foot wellness center, medical, connected to a dispensary. And right now I'm operating only on a cultivation only, like the gentleman that went up first. I think it's important to be vertically integrated for several reasons. What's happening in the market here is Nevada, out of every state, there's 28 states with medical, there's 8 with recreational. What's happening is Nevada is the only state where the wholesale price is continuing to climb. Some of the wholesale flower is between $3,000 and $4,000 a pound, but overall it's higher than any state. What that's doing is causing the retail price to be higher, it's causing the black market to be bigger, and it's causing less options, since not everybody's vertically integrated, for your medical patients and your adult use patients. And I think what you really need to look at to help provide more benefit to medical patients is by opening this up for more people out of these 10 licenses to have a chance to get them. Otherwise, we're going to have less product, and it's going to be it's not going to be as diversified. Our facility that we're planning on building, that we're putting an application in 3 days, is going to roughly have 46 to 50 employees. We're looking to pay in $1.6 million a year in taxes. About seven.
Are you for or against the ordinance?
I think it needs to be refined. I think it's very unclear. I'm all for having a medical section, but I'm not for limiting people that don't have a medical license now, because no one has a medical license in a dispensary unless they've already had one in the prior go-around.
Okay, thank you.
You're welcome.
Let's just go through public comment. Come on.
Hi, good morning, Council. I just need to reference that a letter was submitted to the clerk. The clerk's pulling it up. Thank you very much.
What is it? Well, I didn't. What's the letter say?
Chair. What's your
Why don't you come on up here?
name and address?
Tell us your name, and then you can summarize the letter.
Oh,
just got it.
it's not my letter. It was just a clerk memo.
On the backing of Mr. Bradley, is that what you're saying?
Yes, that was his letter.
So you're for?
I
or
just
against,
didn't.
You're for or against the ordinance?
I'm against the ordinance.
You're against the ordinance.
I would like it struck.
And you, okay, thank you.
And I would also like to shout out to the trades at the back of the room, that each one of these facilities is going to spend about $1 million building another marijuana dispensary, and we'd like to put them to work. Thank you.
Okay.
Her name for the record?
We need your name, sorry. Come on.
Shout.
Thanks.
I forget. It was my privilege to work with you guys for all this time. This is Christine Kramer, and I'm here with Greenleaf Farms, 1771 East Flamingo, Las Vegas, Nevada, 89119.
Thanks.
Thank you.
Anybody else want to speak on this? All right, I'll close public hearing. I don't know, this is very confusing to me. I'm not sure if I support this. It's just, it's a little convoluted, a little confusing. Councilwoman Fiore, do you have any comments?
At best, I think we have to kick this down the road, because we've had many conversations with our dispensaries as well. So at best, I say we obey it again for at least 45 days. Or, yeah, because today it's just not workable. I mean, first this ordinance, first we're saying, you are not getting licensed in the city, we've got enough. And then we're saying, okay, we're going to amend it and you can get licensed. So I just say, let's just create something clean and fresh, but this ain't it.
So I'll pull a bill if nobody's speaking for it. What's the best way to do it?
Just to get rid of it?
Well,
Okay, so if the motion is to, just to surmise, I don't know if this is going to happen, but if the motion is to get rid of this bill, what do we just recommend no? And then it still has to go to the city council, right?
recommend don't pass.
And then it goes to the city council for final vote. It still has to do that.
So
Okay.
if we do that, though, so I would prefer to obey it to where we get language clean, instead of giving it to our peers, all this muckety-muck.
You know, were you asking me?
Yes.
Oh.
I would prefer not to give our peers this. It's quite mucky.
I agree, and I agree now, and I think, though, as Val has just suggested to me, that the bill is not clean right now. It needs to
Right.
be cleaned up. Why don't we obey it for a month?
Yeah, let's obey it for 45 days, because we don't have a second meeting in September.
Fine, whatever.
Okay.
To the first
So
recommended
motion
meeting.
to obey for 45 days.
So what's going to happen in 45 days?
He's
It's going to rewrite it.
I don't know how to clean, I don't know how to clean the bill up because it showed an original bill. It had to be changed. The only way to make it clean is to start over with a new bill.
Okay, so start
So what
over.
I'm saying is, if you want the bill in the process, it'll come back looking maybe as ugly as it does now, but maybe with changes that people want. But in order for it to not have, has a dual character, you can't, but you can. In order for us to start over, to make it clean, it has to be a clean start.
So what do you recommend as a motion?
I don't have a recommendation because I don't know what your time frame is.
So why don't we just kill it, right?
Well, we've already gone through the BIS, I think.
Well, it's just a mess, and I'm so sorry that we've put you through this. I know we make you guys jump through hoops, and then we change our mind. But it's just like, we need to come up with a clean bill.
Council. Well, if it has to come to the council anyway, regardless of our vote, we're simply reporting. The council could, in the next, what? When is this on the general file?
This would go to October 3rd meeting for a vote.
I don't want to kill it totally. I'd rather have it stricken or in some way or another held, so we can caucus together and try to figure out who supports it, because I don't see
So
anybody
why
out
don't
here
we just
supporting
make
the
a
bill.
motion to obey it for 45 days, so we can get our own feces aggregated up here, and then we can go for it.
That's the subject of another bill.
All right, so there's a motion so when would this go?
October 15th.
Okay, October 15th. All right, I'm going to vote no on the motion because I think this needs to die and start all over again. So the motion is to obey this till October, I'm sorry, the motion is
15th.
October 15th, recommending committee. All right, all those in favor?
Aye.
All those against? No. All right, motion carries. This will go to the October 15th recommending meeting. Thank you.
Chair, if I could maybe recommend that those persons who said they had comments or recommendations or conditions, either get them to Val or get them to Councilman or to one of you, so that Val can then incorporate that information.
Okay, good.
I'm sorry, Mr. Chair, that nobody spoke up for it, only because I knew there were people that were in favor of either the First Amendment or the original bill. Thank you.
Okay. All righty, so we will now go to, get my stuff together. All right, item number 4, which is Bill 2018-24, Bay and Sidon for possible action. Amends LVMC Title 19, the Unified Development Code, to adopt additional standards regarding the repurposing of certain golf courses and open spaces and consolidate those provisions with previously adopted public engagement provisions regarding such repurposing proposals. So I have been told that Councilman Soroka would like to make a public comment on this, so we'll go ahead and have him go first if he's here. He's coming. Okay, and then Councilman Coughlin will go in the back, so we don't have a quorum, and then we will continue on from there.
Thank you. Thank you, Mr. Chair.
Thanks. I always do that. Thanks.
Mr. Chairman? I just wanted to clarify that what you meant was so that we don't have a quorum of the city council. You do want a quorum of the committee?
Yes.
Okay.
And we would, right? With Councilman Soroka here. Correct. Thank you. I think so, yeah. All right, Councilman Soroka, you're the sponsor of the ordinance. You have the floor, and then we will continue on after you're done speaking.
Thank you. Thank you. I appreciate this opportunity, Mr. Chairman, as a sponsor of the bill, to have an opportunity to speak. This is the first time anybody has heard from the sponsor of the bill in any forum. So this bill has attracted a lot of attention and unfortunately a lot of misinformation as well. And I appreciate the chance just to briefly put things into some perspective as we move forward. What I'll do is I'll make a statement, and then I'll ask the city staff and the attorney to add any additional information and correct any misstatements on my part, and then I'll depart so we can get Councilman Coffin back in. So I appreciate that. Processes are put into place to help complicated and controversial issues to move forward. Good processes give everyone a voice so that all can be heard and the best possible decisions can be made. And this bill establishes a process where none currently exists. Our challenge is this. Our City of Las Vegas challenge is that as our city expands to the limits of the valley, spaces for development are limited. That makes interior spaces available in the city more appealing, where our rules do not currently work very effectively. These open spaces have had communities built around them, and in many cases, there was a promise between the city and the community that those parcels would be open space as a requirement for the development in the first place. So when the city is considering rolling back on what was designated as open space and rolling back its commitment to the community due to a request from a developer, nothing wrong with that, you should do so with full knowledge of the decisions that the council would be making. Golf courses are among those parcels of land that are attractive, and it makes sense. Golf courses are a failing business nationwide, and Las Vegas is no different. We have many current and potentially future golf course failures, and there's pressure to develop on this and other open space. Open space, parks, open space, they provide opportunities inside of completed residential communities where they were developed. These include parks, they include man-made lakes, and they do include golf courses. And there are some communities that think they are protected. All it takes is one thing to change for those so-called protections to go away. Just consider Legacy that had protections. It's being developed on now. And even Silverstone is in trusteeship by the county and considered for resale. As the ward with more than double the open space of any other ward in the city, it makes sense that I would lead the effort here and direct the staff to build a policy and a bill from the nation's best practices of success to help the entire city. As the maps show, the areas highlighted in red are the specific parcels of land across the city that could be affected by this ordinance. It is defined very carefully and specifically, so it is not a random application of this language, and it would help the entire city. Let's consider again, Ward 2 has more than double the potentially affected acreage than any other ward in the city. That's the ward I represent. Ward 2 also has more than 4 times the acreage of potentially affected land than Ward 6. You can see that on the maps that are in front of you and should be on the screens above you as well. Now, I asked the city staff to develop this document, and they've used no original language. They used the best policy and research and practices from research papers of success from around the nation. And then they broke the document into 2 parts. The first part was the public engagement that we approved in May that talks about the communication between any potential developer in the neighborhood. And then this part is considered the development standards that it's been vetted for the last year. To vet it, we had 3 committees. We had a policy committee and 2 stakeholder committees. We had developers in one group and residents in another, and they were able to hash this out. No one was excluded, all were welcome, and all items were considered. Further, 30 days ago, when I heard there were some concerns, I asked the chair of this committee to delay this decision for 30 days so that comments could be considered. And all comments that came to me as a sponsor were addressed. The ordinance was created by our city staff and our city legal team, the experts in the field. They understand the terminology. They will also be responsible for interpreting the language. And before I wrap up, I just want to add that our council always encourages dialogue and resolution between developers and residents without city involvement. But keep in mind, the city does have responsibilities to all the members of our city. And so there are some things that are solely the city's responsibility, and those include impact to taxpayers, infrastructure impacts, environmental, police, fire, schools, medical response, sewer, and drainage. And this language helps that process along. So with that, I'll ask Robert Summerfield or Tom Perigo, if there's some things I misstated, that we could further clarify. I'd appreciate that. Robert? Chair, if that's okay with you?
Yes.
Mr. Chairman, through you, I believe that the sponsors walked through his process and the process that staff went through in developing the proposal that's before you. I do know that there have been, even in the last few days, some additional conversations about changes that may come forward as a First Amendment, including discussions with the Home Builders Association. They've discussed with the sponsor, and I believe he's supportive of including an exclusion for projects that are within existing residential communities where the Homeowners Association, through some action of their CCNRs, have approved a repurposing project in their development. So we've got some language that we would need to work on for that as a part of any First Amendment that might come forward. But I believe that summarizes what we've been working on.
Very good, thanks.
Tom, and Robert and Tom are in the room, and we came up with this concept a year ago. That's why they've been here from the beginning.
Mr. Chairman, I think between Councilman Soroka and Mr. Summerfield, they've covered pretty much the highlights.
Okay. Thank you very much. Appreciate your time. And if we get Councilman Coffin back here.
Thank you, Mr. Chairman. Appreciate it.
Thanks.
I'll hobble out of here.
I was going to do public comment, but if you want to ask questions. Okay, you're going to take those signs down? Or they're maps, right? Because I didn't, okay, thanks.
Okay. Thank you. So as we had met with staff, because this ordinance affects the whole city, and Ward 6 is the city that has the most development in the future. So I just want to be crystal clear, and I have several questions for staff. So Mr. Summerfield, Mr. Perigo, I want to make sure that everyone is very clear on this, because it is not, open space is not clearly defined in this ordinance, and will this lead to confusion when applications are submitted? Number 2 is repurposing is also not clearly defined in this ordinance, and your reply to the questions I had previously submitted, you stated that it seems, which seems is a big word, and would seem, when asked about specific instances and whether they would trigger the open space requirements. Unless we have specific language that is clear on its face, it will be up to a court to determine legislative intent. Will this lead to confusion when applications are submitted? Number 3, it is also not clear whether this ordinance is retroactive. In your replies to question 1 previously submitted, you unequivocally stated this ordinance is not retroactive. Is it staff's position that this ordinance is not retroactive? I would like Mr. Summerfield and Mr. Perigo to state that on the record. Is this clear? This is not retroactive.
So, Mr. Chairman.
Yeah, so you have, I think, 3 questions there, I heard?
No, I have a few.
Oh, we have more? Okay,
Yeah.
all right, let's start with those.
Okay, so on the specific of that last one, retroactive, so the bill as written is not retroactive. It does not apply backwards to any development such as, again, we've just recently completed the Village of Centennial Springs, so that would have been an open space. It would have qualified under the provisions of this code. However, this does not go back and require them to do it. They have new entitlements, so it doesn't anyway. But if for some reason that project hadn't completed itself and was still going through the system, this would not go back to that project. It's not retroactive
So
as written.
To be clear, part 1, and then this part 2, let's say this went through, you're telling me that it would not be retroactive with both of them out there together?
Mr. Chairman, through you, correct. It doesn't provide for anything retroactive. Now, I do want to be clear that there are provisions under the closure, area that would allow for the city to require some level of maintenance on a closed facility, because the language does say something along the lines of, once we've been made aware that a location has closed or may close. But again, it's not retroactive as in we're going to go back and make you put in a golf course where a golf course used to exist. It would be that some level of maintenance plan may be required.
From what point? That's what I'm saying. So that's why, see, it's not clear, because when you're saying, so if we had the maintenance closure point, from at what point would we have to go back? That's just not clear in the written. The reason why I'm asking you these questions is because I've met with my Silverstone folks, which is a golf course, and the Councilman Soroka has met with my Silverstone folks. I've met with them 3 times after that meeting with Soroka, and we are not clear, and we would like, and I have several more questions, but this particular ordinance needs to be obeyed until we're having a huge Silverstone meeting with probably 200 to 300 of our folks meeting and discussing this ordinance together as a whole, because it's just not clear. And then I also want to ask, except for the environmental impact study and the 3D model, all the requirements in this ordinance are required in major developments. The city usually requires traffic, drainage, sewer, water, parks, and school studies after the development is approved. Does planning see an advantage of requiring these developments to pay everything forth and then not be approved? I mean, we're looking at developers going, hey, we're not going to risk that. I mean, do you guys see an advantage of having our developers, which have been practicing business for ever since we've been a city, do you see now why we're going to have this forthcoming first instead of after they're approved?
So, Mr. Chairman, through you, Madam Councilwoman, so there's always a benefit to making decisions based on more information. It's a policy decision of this council whether or not they wish to have the information that's available in those studies at the time that they're approving or hearing an entitlement application or not. As staff, of course, I like to have the best information possible for when I make a recommendation to you. However, as you pointed out, it has been the policy of the City Council to not require those studies and to allow staff through administrative processes to update entitlements and update development programs through the process post-entitlement if something does come up because of one of the various studies that are required prior to issuance of permits. So again, more information is always great, but that's a policy decision of the council on at what point they want to have that information available to themselves or to staff to review.
Thank you. And then in a meeting in my office, you said planning did not have the staff or the time to tell me what properties are affected by this ordinance. Is this still the case? Because my peer, Councilman Soroka, just said Ward 2 trumps all of the other wards, and I must disagree. Councilman Anthony has minimally 2,000 acres in Ward 4, and I'm going to say I trump them both in Ward 6. So can you tell us today, or even by the date of the ordinance that might be enacted, what properties exactly will be affected in Ward 6?
So, Mr. Chairman, through you, Councilwoman, yes. So to be very clear, the analysis that's in the maps that have been distributed to the council and that the councilman had as a part of his review at the sponsor, these are based on a GIS level analysis of the properties that currently meet the criteria for applicability in the ordinance. As I have told you and told other council folks, I do not have the staff right now to go and verify each property makes that determination. This is a high-level GIS, Geographic Information System analysis, of the properties that we believe as of this moment in the data that's in our GIS system would potentially be applicable underneath this ordinance. Until a repurposing were to come in for an open space and we were to verify it through the test, I could not say definitively a property meets the criteria or not until it's actually presented to us.
Okay, so then, thank you, because this is the first I'm seeing of these maps, and staff and I just met on Thursday. I've met with my folks Saturday, Monday, Thursday, and Saturday. And so in the reply to the questions I previously submitted to you, providing a spreadsheet of some of the lots you have identified as subject to this ordinance, I would like to submit into the record the synopsis of the spreadsheet, and I'll give it to Luann and I'll give it to my peers, showing the average lot size by ward, the medium lot size by ward, the minimum lot size by ward, the maximum lot size by ward, and the total numbers of lot you have been able to identify. For the record, citywide, the average lot is 1.76 acres. The medium lot is 0.79 acres, and the minimum lot is 0.10 acres. So the maximum lot is 81.94, and you have identified a total of 281 lots, of which 109, or 38.79, are in Ward 6. So I assume that you cannot verify my numbers at this point, but does that sound reasonable to you, Mr. Summerfield?
Mr. Chairman, through you, Madam Councilwoman, yes, the review of the data points does seem to agree with that. Again, I don't have those specific numbers, but I have taken a look at those. A lot of the ordinance does not set a minimum threshold presently, and as such, in our GIS data pool, it pulled all properties that seem to meet the criteria regardless of size. So that's why you do see quite a few smaller lots that would, again, through the GIS pool, seem to be applicable under the repurposing ordinance.
Okay, and then, again, legal questions. Again, it's not clear whether the ordinance is retroactive because of the closure thing. And I served on the Assembly Judiciary Committee for 2 terms while I was in the legislature, and I know how important legislative intent is. And if a reading of an ordinance or statute is not clear, a judge is required to determine the intent of the legislative body. So I would like to ask you the same question I asked planning. Is it the city attorney's position that this ordinance is not retroactive, and would you please state it again so that this intent, so that this is the intent of City Council? Mr. Val?
I guess that's you, Val.
As Mr. Summerfield has said, there's nothing in the ordinance that operates backwards in time, although there is that provision that says when the city gets notice of a golf course or an open space either being closed or withdrawn, then that part of the ordinance becomes effective. It's not retroactive in the sense that it won't, if the council doesn't adopt the ordinance, of course it doesn't go into effect. The council adopts the ordinance, and beginning at that point, anybody who has an existing golf course or open space then would be subject to that provision that might ask for the filing of a closure maintenance plan, and anybody who then wants to repurpose that open space or golf course would then be subject to the provisions of the law. But it doesn't seek to go back in time to folks who have already come before you with a repurposing proposal and do something different to that proposal.
Right, it doesn't seek to, but it can.
I don't think you'd find anybody on staff asking for it to.
I get it, but our staff isn't going to be in the courtroom. Do you understand? And I'm telling you this as a former legislator, this is how it goes down. So we think we know the law, and then the judge dictates what our intent was.
I understand, although if you look at any ordinance in the book, it's always that way.
Okay, so bottom line.
I can't
City
write this
Council,
ordinance any better
not
than the ordinances that
retroactive.
are
Do you
already-
agree? City
Beg your pardon?
Council, not retroactive.
Right now, the city council can add a retroactive provision, but it's not in the ordinance right now.
Okay, so Section 7 of this ordinance specifies each day of noncompliance to this ordinance constitutes a misdemeanor violation and shall be punished by either a jail term or a fine. If this ordinance had been in effect when Silverstone was closed, that would be 1,099 days through today. Would the city of Las Vegas be prepared to file, to basically put someone in jail for 549 years and over $1 million in fines? I mean, this is what we're looking at.
Let me just point out that all the provisions of our code are subject to misdemeanor prosecution. So there's nothing different in this ordinance than exists in all the
Really?
ordinances.
So you're going to show me a previous ordinance that says 6 months per day? Can you show me that? Because
Sure.
it's not happening. Okay, good. You show me that because I don't think that's true. And then municipalities in Nevada are only allowed to issue misdemeanor citations. So I just want to make sure that we're clear because I'm asking again for this to be obeyed for 45 days because my Ward 6 is very affected by this. And then if an LLC or a corporation declares bankruptcy, are the fines under this ordinance able to be discharged? There's so many
Your ordinance will not answer those questions. The law answers those questions.
Okay. So if a golf course does not close but does stop watering the golf course, does that trigger any portion of this ordinance?
The watering doesn't, but if the...
Right. So these are the issues that we have with this
You will
ordinance.
have these issues no matter what the ordinance says.
I got it, but this ordinance is overreaching minimally, and so until we can get this together with our builders and my staff, I'm going to ask for this to be obeyed for 45 days.
Okay, so let's go ahead and have public comment. Looks like quite a few people out there. What we basically would like to hear from each of you, and I'll see how it goes. I may put a time limit on it, but we just want to know, are you for or against the ordinance, and just real quickly why you're for or against it. That's what we want to hear from you. So please don't filibuster out there. Just get your point across. And make sure that you state your name at the beginning. All right, go ahead.
Hi, my name is Burton Steinberg. I live at the Lakes, 3141 Waterside Circle, and I have lived at the lake since 1987. I've watched us going from the end of the world to the beginning of the end of the world, and I approve of Councilman Soroka's bill here. As far as what the young lady was talking about here, I look at the exceptions in the bill, and that might cover some of it, and I don't know if she's alluding to this alone or besides the other laws that may be
Okay. Just state your comments, and then we'll go on to the next person.
Okay.
All right.
That's all.
Thank you, sir. Appreciate it.
Good morning. My name's Christine Kramer. I'm an individual citizen, 8221 Silver Catfish Street. I was the liaison for Ward 6 for 3.5 years before Councilwoman Fiore was elected, and I had the pleasure of serving the residents of Silverstone. The current process where we are able to levy code enforcement fines is working very well to motivate the present owners of the land to come forward with the city and negotiate. This bill does rob, in my interpretation, rob the city its ability for the elected council person to negotiate an agreement based on a settlement of those code enforcement fines and bring forth a better project or bring forth a project that would more clearly benefit the residents of that community. This bill needs to go back. It's ambiguous. I live 2 blocks from Silverstone. There's still a lot of confusion in the community about the bill. Right now, code enforcement holding the property owner accountable, it's working. This new bill is going to add a level of confusion and will not have the types of hearings that the residents are able to benefit from, and it takes away the ability of the council person. The previous council person, as you may recall, we held hearings and set liens for code enforcement violations, and this bill doesn't allow that mechanism or the ability for the council person to negotiate such an agreement.
All right, thank you.
Thank you very much.
Next.
David Arpin, 7635 Maggie, Ward 6. I would first like to thank Mr. Soroka for proposing this very much needed ordinance, which provides an open and transparent mechanism to deal fairly with this really very dark problem. The problem, simply distilled, is basically asset stripping of the homeowners of Southern Nevada. Millions of dollars have been spent on legal fees fighting to preserve our neighborhoods. People have paid a premium to live in these communities, and through bankruptcy, legal action, golf course communities have had their golf courses purchased by interlopers at below market values to sell to developers. These interlopers have used the bankruptcy courts, shell companies, and other nefarious moves to deplete the homeowners associations out of all their financial reserves. We, the homeowners, plead that you will support this proposed ordinance, which will restore our belief that when financial difficulties do arise, that there's a mechanism that's going to be in place that will fairly and transparently deal with this issue so that everyone knows that the community that they're buying in has some type of mechanism at our disposal.
Thank you.
Thank you so much.
Thanks.
May I ask him something? Sir, the person who just testified, did you have your comments written form? Are they written, your comments?
I did write them.
Then please give them to our clerk so we can see them, or edit them if you want and then give them to the clerk. Sure. Thank you, ma'am. Thank you, Mr. Chair.
Yes, sir.
Good morning. For the record, my name is Kenneth Evans. I'm here before you as a private citizen, 5419 West Tropicana Avenue, 89103. I'm also here as an individual that has had the opportunity to participate in several infill development projects within the city of Las Vegas. Therefore, I'm here in support of this ordinance because I think it does two key things. First and foremost, it comes up with a process and a system to make sure that, true to what Councilman Soroka said and other members of the council, as you face a land availability crisis, if you will, we ensure that we have a process that will take into consideration the rights and the desires of the existing homeowners and residents for a particular ward. So that's point number one. And then point number two that I'd like to mention is that this comes up with a process that will also take into account any impediments or any barriers or any consequences related to the existing infrastructure. So again, here, as someone that's been directly involved in past infill development projects within the city, I think it's well warranted to have an ordinance that establishes a process and a system to ensure that there is responsible infill development that is both fair to a potential developer as well as to the existing residents. Thank you very much.
Thank you, sir.
Thank you, Mr. Evans. Do you live in the county? Because you don't live in 2 or 6. Where is it that you live? What ward?
I'm not in a city ward.
Right, you're in the county.
That's
Thank you
correct.
so much for your comment.
But as I mentioned, I've been involved in several infill development projects.
Thank you, sir. Yes. Just a couple minutes, right? You got
Correct.
a lot of stuff in front of you. so-
Yes, Mr. Chairman, members of the council, Stephanie Allen, 1980 Festival Plaza, here on behalf of the 3 landowners for the former Badlands Golf Course, 70 acres, 4 stars, and 180 land. We're opposed to this ordinance. The Planning Commission heard this in 2 separate sections and recommended denial of both sections that have now been merged into one bill. We'd ask that you follow their direction, as they did take a lot of testimony and consideration in hearing these ordinances. The reason we're opposed, number one, is we believe the intent of this ordinance is directed directly at my client and the former Badlands Golf Course. I know your council will disagree that it's been drafted to apply to the citywide, but I would like to just put on the record some of the reasons for our specific concerns. And if I could use the overhead, if we have that available, please. This is a chart that shows 16 of the golf course properties in the city of Las Vegas. And you'll see in this column right here, it shows the restrictions that are on all of those golf courses. Badlands is the only golf course that's currently single-family vacant land. It's zoned RPD 7, and there are no restrictions on the property. So it's actually available to develop today. The rest of the golf courses are all restricted by either restrictive covenants, the city owns them, or they're operated and controlled by an HOA. So in theory, you could say that this ordinance will apply to them, but there are protections in place that will not allow the repurposing of those golf courses without a number of hurdles to first overcome, private hurdles to first overcome. So I'll submit this for the record. The argument that we have and the concern that we have is you may say it applies to all of these golf courses, but practically speaking, it really only applies to the Badlands. Also, there's retroactive language, as the city attorney discussed and Mr. Summerfield, that we're very concerned with. And the reason is, if you look at Section 3A, it specifically says that this is to apply to golf course or open space, whether or not currently in use. So Badlands closed 3.5 years ago, and this particular bill could apply to a golf course that was closed over 3.5 years ago. So it's not, because it's not currently in operation. And then it goes on to say that you have to comply with all of the provisions, including the closure plan, which is subsection G. When you go to subsection G, it specifically says at any time after the department becomes aware of the golf course closure, that it's subject to this section, if repurposed, has ceased operation or will be ceasing operation, the department may notify the property owner of the requirement to comply with this section. It's selective. So from our client's perspective, that's very scary, that the city could, and I'm not suggesting your staff would, because they are wonderful and we work with them every day and you can't have better staff, but possibly at the direction of someone else, could apply this particular ordinance to our property 3.5 years after it's been closed. And if that's the case, let's say we submit an application tomorrow. If that's the case, then what do we have to do under this ordinance? It's not clear. Their fear is, when you read this language, it says that you have to maintain the property at, the maintenance of the property, I don't have the exact language in front of me yet, similar to or the same condition that it was in at the time of the closure. Well, obviously, that is extremely burdensome on property owners if they're in financial trouble or if they're trying to redevelop in a situation like Badlands that has been a 3.5-year fight. You cannot maintain a golf course for 3.5 years in its same condition while you're fighting an ordinance and development and things going on. Not to mention, to retroactively expect us to put it back in that condition would obviously be extremely burdensome and ultimately a taking of the property. So that's the fear, and we're not quite sure what that means from a closure standpoint, what we would have to do.
I have a question on that. If I could ask a question?
Sure.
Through you, Mr. Chairman. Question is the city did not order your client to kill the golf course. That's a self-imposed kind of, if I'm not mistaken. Did we order you to close the golf course and stop supporting the golf course?
Through you, Mr. Chairman, if I may, absolutely not. And as your colleague, Councilman Soroka, said, there's obviously a trend nationwide for extreme declination in golf and the need for golf courses. So there absolutely is a future of redeveloping golf courses. But the problem with this particular ordinance is, in your city, there's only one golf course that this ordinance could apply to. And if you make us go back and put the property in the condition it was on the date of the golf course, that's extremely burdensome, costly, and it's ultimately a taking. And then it becomes an encumbrance on the property as well, because the closure plan has to be recorded against the property. So you record it against the property, and then you have a lender that's upset because you've got an encumbrance that the city placed on the property without the property owner's permission. So it's a domino effect, and then you try to have a developer come in and maybe want to buy it. Well, now the land is extraordinarily devalued because people don't want to spend a year and a half trying to comply with a bunch of requirements that have not been a part of this city's.
Is there a lender involved in this situation?
Yes, and they're actually here to testify.
Who is the lender?
I don't know, but they are here today.
Okay, we're discussing the ordinance. We're not talking about Badlands, so keep going.
Briefly, just real quick, the concern is the retroactive nature of it, and again, the encumbrance on the land, as well as the possible selective prosecution. And I know Val will say that there are other ordinances in your code that specifically have misdemeanor provisions. The fear here is that this particular applicant has undergone a lot of scrutiny and special situations, and the fear is that he'll be put in jail over this particular provision. And that's a real fear, and I'm putting it on the record so that you all are aware of that fear. Even if this were to apply to all development within the city and not just to one developer, it's an anti-development ordinance. It's not pro-business. The city has not been that type of jurisdiction. In fact, right now, you're probably one of the quickest jurisdictions to process development entitlement applications and engineering studies. It's very pro-development right now. Developers will not want to comply with this ordinance, and the first thing you'll see if this passes is developers coming in and asking for some kind of exemption or change to it, because it's just not pro-business. And the reasons are, I'd like to just quickly go through the list, an environmental study is required. That's a California thing. There's no situation that I'm aware of in Clark County where a phase 1 is required prior to the submittal of an application. To do drainage studies, traffic studies, all of those master studies on the front end, you only see those with major projects like development agreement projects, not on a 5-acre parcel of land that someone's trying to repurpose from open space. Also, in situations where maybe a developer has held off a couple acres on the corner that they plan to develop at a future phase, there's no incentive to open that up as a park temporarily or to use that land as an amenity for a commercial development if a developer knows on the front end that they're going to have to comply with this ordinance with a bunch of burdenous restrictions. So instead, the land will sit vacant and it won't be an amenity for the overall community. There's a GPA required, a master plan and phasing plan required, a 3D model required, the closure plan that's required and that you have to file and actually record against the property. For infill development, which I heard someone mention, it's extraordinarily difficult because it requires you meet or exceed the surrounding setbacks. It won't allow any accessory structures over 15 feet. So in an instance like Badlands, where you have beautiful homes with very tall homes, very tall accessory structures, you're limited to what you can do on property.
Okay. I think you've...
I have. Just one other point,
okay.
if I may, Mr.
I think we have your opinion that you are against the ordinance.
We are against it.
Okay.
And one thing, we'd ask just for clarification how this is going to proceed at City Council tomorrow. I know it's on the agenda and it says it's for a future date. We'd just like clarification on that because at the last hearing on this Part 1, there was no public comment accepted and it was adopted without public comment.
I'll wait till when we make the motion, then I'll explain. I'll have the dates all up here, but I have to wait for a motion before I can give all that information out.
Okay, appreciate your time. Thank you.
Thank you. All right, come on up, state your name. Yes, sir.
Good afternoon, Dale Reisner, 9811 Orient Express Court, Las Vegas, Nevada, 89145. Excuse me. Thank you for taking the time and effort to focus on this ordinance. I'm in favor of it, and for several reasons. Just Stephanie Allen just before me stated, this has been going on for 3.5 years, and this ordinance offers some direction, some clarity, some expectations on how to proceed. And she even mentioned that a developer wouldn't want to do this because it might take 1.5 years to put it all together. But if you're developing something on the scale that they're looking at specifically, and I'm not speaking to all the other places that are affected by this, it would seem to me that 1.5 years would have been time well spent to focus on it, get to the bottom of everything. And so I really think that we would be far better off with this fundamental guideline in place, and we might have had this resolved 2 years ago instead of 3.5 years. And right now we're no better off in our example than we were when we started. And the mayor even has said at a council meeting, she says, I think this is going to come down to the courts to have to decide. And it really points to the absence of a process. And so I think you've got a lot of good elements in this. I appreciate your efforts, and please support it.
Thank you, sir.
Good morning, Elaine Winger-Reisner, and I just wanted to, 9811 Orient Express Court, echo my husband's opinion and say that I do support this ordinance. And regarding code enforcement, a point I wanted to make is the present process is definitely not working at the Badlands because we can't even get information on the heavy equipment and the work that's presently being done on the golf course land. And the other point is, I know there's been some discussion about the delay and people could be employed and that we have messed about this for 3 years, but actually there's 3 years that nothing has happened, and to have a process in place that's very clear, I think would be very helpful for the city moving forward. Thank you for your time, and I appreciate all your work.
Thank you.
Good evening, good morning, Sigal Chadha, 3017 Oceanport Drive. I am in Mr. Soroka's ward, and I actually sent out an email to all the council last night, and I expected to get some answers, but the only councilman that actually responded to me was Mr. Coffin. I have a few questions that I would like answered, and then I'll reiterate something that concerns me that Councilwoman Fiore said. One of the issues that I have is that Mr. Soroka said that the Badlands Golf Course is an open space for all of the residents of Ward 2. Now, as a resident of Ward 2, I would like to know who is paying to maintain this open space. So, again, the only councilman that responded, and I did not receive a response from Mr. Coffin as to who is paying for the open space. So that's one issue that I'd like to have addressed. Another one that I'd like to address is Councilwoman Fiore mentioned that there's some issues with the ordinance as it is drafted. It is vague. Unfortunately, we don't have enough information with the ordinance, and she mentioned that as part of the legislature for judicial review, I believe it was, Ms. Fiore, that this ordinance would be very problematic to uphold in court. And one of the issues that I have as to this is the legislative intent. We have not heard anything. Is it retroactive? Is it not retroactive? Does it single out one specific developer? Because we know, by the way the ordinance is drafted, that every other golf course, as was mentioned, is already out of the picture. So if we're singling out one developer or one property owner, we've got a serious issue. We've got equal protection issues that come along with it. Again, retroactivity, we know that constitutionally, we can't have ex post facto laws in this country. So if any one of the council members would like to address those issues, I would appreciate it.
Okay, we have your email, so I'll have our staff send an answer.
Thank you.
Thank you for coming down. Yes, sir.
Morning, council members. Mike Tomko. I live at 9717 Fern Canyon Avenue in the Lakes, Turtle Creek section in Ward 2. The Lakes has been my home for almost 15 years. Our community, we're looking at our community, the Lakes, not all this craziness that's being discussed here today. And our concern is we want to keep it preserved the way it is. As far as this ordinance goes, we support it. I'm representing several people here from the Turtle Creeks community, and we want to keep the lakes as beautiful as it is. I'm a retired firefighter and fire commissioner from New York. I'm also retired from Las Vegas Fire as a fire dispatch supervisor in the 911 office. So looking at things in a public safety point of view, and this bill realizes our normal development procedures right now doesn't accurately address the stresses on infrastructure and services that can happen in this type of development. Public safety thrives when you enhance their ability to protect and serve instead of overdevelopment and compromising that by, again, overdevelopment and profit. I want to commend Councilman Soroka for taking the lead to this problem because our ward is the most open space and recreational area within our ward's boundaries. We have a great need for a clear and transparent process to reduce the confusion we have witnessed in this city for several years, and I think this bill is worthy of compromise from all involved to create a good process. The ordinance will be a path for everyone involved to reference. This path forward utilizes existing policies and procedures. The reorganization will not stop development, and I've heard a lot of that today, and will not jail anyone without breaking a misdemeanor law that would warrant it. I've heard a lot of accusations without any explanation from the opposition to the ordinance. The inability to articulate how their accusations will actually happen from this ordinance further validates why you, the City Council, and this committee should support the bill with a yes vote. Thank you for your time, your consideration. I'll leave this for him.
All right, thanks. Yes, ma'am.
Kathleen Olander, 8564 Grand Palms. I live in Ward 6 in Silverstone, and I have a business and office building in Ward 2, so this greatly affects me. I'm here representing both neighborhood association groups and several equestrian groups. We are in support of Mr. Soroka's ordinance. We feel that, especially in the Northwest, it's imperative that these open spaces are dealt with intelligently, to preserve the quality of life, both from a public safety perspective, police, fire, flood, drainage, and schools. Now, in the past, I've gone to city council meetings for over 20 years to work at thoughtful plan development, and city makes guidelines and we try and follow it. What's been happening, in the past is when we have city development, we have all this open area, and the city can play catch up and get a fire station in. When we're talking about developing these infilled areas, what's happening is if we don't have an ordinance to be transparent, what's going to happen is just what Councilwoman Fiore said, is if it's not transparent before, and I think it's imperative that you require any developer who is going to develop an open space that these plans are done in the beginning, because once we have the infrastructure, we can't change flood, we can't make, increased, fire, police at certain stations, now all of a sudden when we put high density in. And I've worked with City Council, and we worked when density was increased, we were given assurances that it was offset by open space. So now you're telling me 15, 20 years, we fast forward, now you're saying, oh wait, this is open for negotiation. We can build now and put high density and get rid of the open space. There's no plan, and what we're going to do is erode the quality of Southern Nevada's lifestyle. So I beg you from many vantage points, both as a business person, as an equestrian, we're eroding the quality of life. The Northwest won't have any kind of rural quality, and this not thoughtful planning is a problem. And so an ordinance like Mr. Soroka's is important so that we can be transparent. So when these areas are, if they're going to be filled in, then it has to be done with studies before. Not let's pass it, they can develop it, and then let's try and figure out how we're going to do this. That's why we had all those issues for 20 years with drainage.
Thanks. Appreciate it. Yes.
I'm very quick.
State your name again?
Catherine Green.
Okay.
8245 Dolphin Bay Court, 89128. I'm one of yours, and I would love you to urge recommendation.
Okay, thank you. See, that's how it's done. She's for it. Thank you.
I'm very quick, too. My name is Paula Wild. I'm one of those equestrian farmers at 7670 Brent Lane, Signature Farms. That is a very heavily trafficked road for a dead-end road up to the golf course. There's no police patrol. The fire engines don't come down unless you call for a police officer, then the fire engines come down. We are very upset about the impact it has on the animals that live out there, the peacocks, the roadrunners, the coyotes, the cougars that are coming down now from the mountains, and we don't want to see that impacted without a study. For a developer to do it after the fact is kind of like getting pregnant and figure it out later. You can't do that. You need to program yourself to do these studies ahead of time, what kind of impact for nature. I also live on the street that gets flooded. So that is a very important thing. We already had one on Coke with the Pulte development, which worked out very well because we discussed it. They need to discuss. And I am in favor of the ordinance. Thank you.
Thank you, ma'am. Yes, sir.
I'm Gordon Culp, 653 Ravel Court, Las Vegas. I'm in favor of the ordinance in just less than 1 minute. Show you why. The proposed ordinance requires the developer have a maintenance plan, which you've heard a lot about in the last few minutes. But let me quote you the exact language. The maintenance plan must ensure that the subject site is maintained to the same level as that existed on the date of discontinuance or withdrawal, or otherwise at a level acceptable to the department. So to stand here and say, well, this is obviously absurd because nobody's going to restore the golf course quality, but it can be some level intermediate between where we are now, which is killing trees that are years old, vegetation's dying, there's piles of debris, short of trying to go to the absurd extreme of restoring it as the golf course condition. But let me show you what can happen here if we have no requirement for a maintenance plan, if we can get the overhead. I'm on the wrong place here, I see that now. This is an aerial view of the Badlands area, Queens Ridge area, at the time the course was acquired by the developer. You can see the fairways provide the greenery and vegetation in the open space. There are trees throughout the course. There's a large area here, which was the driving range, which is a big green area. And what do we have now, with the total lack of a maintenance plan, as you see in the lower part of the drawing? This has all gone brown, of course. The wildlife's dying off. I say the trees are dying. It's a really sad situation. So don't let this happen somewhere else. Please recommend the ordinance.
Thank you, sir. Yes.
Hello, members of the council. My name is Craig Newman, 400 South Rampart Boulevard, Suite 350. I represent Vegas Ventures LLC, which is a lender and a deed of trust holder on the property where the former Badlands Golf Course was sitting. My client strongly opposes the ordinance and loaned money on this property based upon the current zoning of the property without deed restrictions. There certainly were not deed restrictions on this property, and it was zoned in a manner that envisioned and allowed residential development. Loans were made on that basis. If this ordinance is passed, and for the reasons that were cited by the attorney for the owner of the property, it appears that this ordinance is singularly focused on this property. And if it is passed and it is allowed to be given retroactive application, there is no question that the collateral that my client certainly presently holds will be decreased in value and possibly rendered valueless. At that point, it will definitely constitute a taking that will be requiring judicial intervention. The other thing that I do want to mention, and Councilwoman Fiore very astutely pointed this out, there are provisions in this ordinance, and you asked staff, tell me whether it's retroactive. And they said no, disingenuously, because it's very clear that the closure provisions will be applied retroactively. And unless we are given an assurance by the city that in fact the closure provisions will not be given retroactive application, this is without question an ex post facto law targeted at the owner of this property. And I'm sure that it will be challenged judicially as such.
Okay, thank you. Councilman Coffin has two questions.
Okay.
Craig, how do you spell your last name?
N-E-W-M-A-N.
Newman?
Newman.
Newman, thank you. Craig, you represent the lender. Who is the lender?
Vegas Ventures LLC.
Okay, do you work for Vegas Ventures?
I'm an outside attorney at Sklar Williams.
Okay, and what address? 400 South Rampart Suite what?
350.
350. Okay, who are the owners of Vegas Ventures?
It is a Delaware LLC. The managing member is Paul Roberts.
Paul Roberts?
Paul Roberts.
Okay. Is this a loan outstanding, or is this simply a guarantee on a loan?
It's a loan.
All right. Thank you very much.
Thank you.
Thank you. All right. Next, please.
Check my time, make sure it's still morning.
Morning, my name is Richard Carrion. I live in 586 Burn Point Avenue, Las Vegas, Nevada 89178. I'm coming here as the president of the Nevada Veterans Association. I've been the leader of the organization now for about 2 years. The last 18 months, we've been directing our members and those who are looking for employment within the veteran community directly toward the union trades, specifically because they're probably about the veteran community is about the fastest you can OJT and get them up and running economically, if you will. We are opposed to this ordinance for a couple of reasons. One, when you have a situation where you have blight, every city council ward based on the surrounding areas has to take their own measures in regards to both engagement in the community and looking at what businesses would actually bring that neighborhood out of blight or other developments that can be used. Obviously, as veterans, we also appreciate the open lands as far as recreation, but I think that this prevents every city council member it denies them a certain level of flexibility when it comes to dealing with what the residents want in their ward and then putting a blanket statement on saying that this should be a blanket ordinance to make this apply to every single situation when every ward has their own issues, their own amenities, and obviously the other issue that we have is the size of area. We have everything from the size of the Badlands Golf Course, where you can put a master plan community in it, and it applies to the very, the smallest parcel of land where you can put a mini mart. So I don't think that this is the best balance in regards to development, and I think that the City Council, if they want to maintain open lands, need to probably re-engage with their own communities, see what direction they want to see their wards in, probably engage with some of the other elected officials, along with maybe going back to the drawing board. Thanks.
Okay, thank you.
My name is Lauren Chase. I live at 9101 Alta Drive here in Las Vegas, Unit 1601. I would like to speak in favor of this ordinance. I've witnessed for 3.5 years what uncertainty does to a development, the peace of mind of the residents, property values, and very sadly what this protracted argument has done to the wildlife. We have buzzards over the golf course. Food, water was just withdrawn very quickly, and I can imagine that time and again the same scenario will play out if there is not a process that is understood in the beginning. The uncertainty that addressing every open space or every potentially redeveloped area, the uncertainty is destructive for property values, and I think it's very good just to have something that says in advance to developers and future homeowners, present homeowners, this is what can be expected.
Thank you. Yes, ma'am.
Hi there. My name is Casey Mosman, and I live at 8337 Normandy Shores, which is inside Silverstone Ranch. And I want to say that I think this should be obeyed today. I'm for an ordinance. I don't think I'm for the way that this one is specifically drafted. I do believe that those that are most affected by the changes in open space and golf courses are the homeowners that bought specifically in a designated area and purchased some of them at above property value prices because of that open space. They paid extra for where they live. And to come in 10, 15 years after the fact where these people have no choice, they become the most affected over the changes to open space. They have zero to little say to somebody who wants to come in and develop their backyard where they thought it was going to stay that way. In our specific case, it was supposed to be in perpetuity. Now, we're not telling somebody that they should have to run and operate the golf course, but for a developer to come in the Badlands case, purchase a golf course unbuildable land at $13,000 an acre so that he could make immense profits and make his margins grow. I think something needs to be in place, an ordinance needs to be in place to protect the homeowners that had zero say as to what was going on there, and that they bought there with an expectation set, as well as the people in the lakes, as well as the people at Grand Legacy, as well as us out in Silverstone. I think it does affect a massive scale, and this is just the bare beginning. We've been going through ours for 3 years now, and this isn't the end that you guys will see of this being an issue. Thank you very much.
Thank you.
Good morning. My name is Jerry Engel. I live at 700 Pontchartrain Drive in Badlands. And you heard the statement, I was for it before I was against it. And when I first saw the initial renderings by Mr. Lowy, I was for it. It was 3.5 years ago. It looked like open spaces, a lot of greenery.
Sir, we don't want to get into a Badlands thing here. We need to we just need to know if you're interested.
Why we need the ordinance.
If you're a supporter of the ordinance, tell us why you're in support.
I'm sorry, but we need the ordinance to protect against using of words, because I attended meetings where they use the words compatible, and all we're asking is that something remain compatible with what we presently have. And the only thing I can say is, Councilman Anthony, where you're sitting is about maybe 50 feet to that wall, and then that goes up about 30 feet. And what is now being proposed right outside of my house, 100 feet away, is going to be 40 feet high. That's not compatible. We need protection with an ordinance that will not allow such tremendous abuse of our view. Thank you.
Thank you, sir.
Good morning. My name is Larry Sadoff, and I live at 9101 Alta Drive, 89145. And I support the ordinance, and I'll be very quick. There are many words or adjectives you could describe the ordinance. One I'd like you to consider is fair. It's a fair ordinance. And you've heard people come up here before, and contrary to Ms. Allen, I think the ordinance will allow developers to make a profit. I think it will allow workers to get a fair wage and get work, and it will allow homeowners and people around, no matter where we are in all of Las Vegas, to have input on the process. So no special interest group, and I've just mentioned 3 of them, gets an advantage. It makes a fair, level playing field for everybody. And for that reason, I ask you to recommend this ordinance to the City Council. Thank you very much.
Sir. Thanks. Come on.
Hi, Amanda Moss with the Southern Nevada Home Builders Association. Almost good afternoon. We're here today testifying in neutral on this ordinance. SNHBA has been at the table since October as the only industry representative on the advisory panel put together by your staff. And since October, we focused our concerns mainly on the scope of the ordinance. And we appreciate that the exemptions in Section B apply to the entirety of the design standards that are outlined in Section C through G, and that we also appreciate the clarification on the record for Phase 1 and hope the same clarification is made for Phase 2 of the ordinance, that this does not apply to communities with planned open space, and it only applies to open space that has been proposed or approved but not yet completed. We appreciate the sponsor as well as staff reaching out to us and some dialogue this weekend to clarify their timeline for the first amendment of the ordinance, and we hope that that includes additional limitations to avoid unintended consequences. But, you know, we are concerned that we still haven't seen that draft yet, and, you know, it's kind of difficult to speak right now on an ordinance that will be changed, but appreciate the comments that staff has put on the record.
Good morning, Chairman, City Council. Today, Nat Hodgson, for the record, Executive Officer, Southern Nevada Home Builders Association. Today, however, we're in a tough spot in this ordinance. We received board direction to oppose any draft that doesn't include our third piece, as Amanda just went over as well, that we proposed back in March. City management has assured our concept will make it into the draft and go before City Council, but we have very little communication on language that addresses communities with CC&Rs, which, of course, when you buy everything that can be dealt with on the property is in your CC&Rs, and as a homeowner, you have control. Or the development agreement that clearly contains provisions governing relocation or redevelopment of the open space. So it would be by the homeowners. Our goal of this language is to avoid the following. If the residents undergo a process to change CC&Rs owned by an HOA, then why wouldn't the council or adjacent communities be able to intervene and place additional requirements on amenities that they're not paying for? Second one is to clarify that it is in the city's interest that these private nonprofit associations remain viable for the cities and historically made efforts not to interfere with these private contractors. Lastly, and this is a big one here, we want to point out that these provisions prior to entitlements that have been read to you will build an additional layer of uncertainty and spending a lot of money before you even know if you can go forward with the project. When developing in the city of Las Vegas will likely disincentivize many of our members, or anyone else for that matter, from coming into the city if this ordinance passes due to significant increase in cost and time and not even knowing if you can do it. Thank you for your time.
Thank you. Yes.
So before Mrs. Hill begins with the Southern Nevada Home Builders, I just want to make sure, because as we've all been working with this ordinance and asking for language, it is not there. And so when I make my motion later, you'll understand why we need more time.
Good morning. I'm Melanie Hill. I'm a Silverstone homeowner, and I'm speaking out in support of the ordinance, but have spoken to Councilwoman Fiore and Councilman Soroka, and we believe that there is stuff that can be added to the ordinance to make it stronger and to make it clearer as to what it applies to. As a homeowner who bought in Silverstone when the community was first developed and paid a lot premium, I expected when I bought there that I would be looking at a golf course and have my open space. And all of my open space in that development is the golf course. So it's concerning to me that developers bought our golf course for less than $4 million and want to turn a $20 million profit to be able to build homes and take away our open space. I think that this ordinance is helpful because they understand going in that if they buy a golf course, there's a closure maintenance plan. They have to maintain the golf course in some standard. They can't just close it and shut it down and kill it like they did to us and then require us to go to court and get injunctions and things like that. I think that the ordinance that's proposed will help other communities that live on golf courses and open space to have additional protections against developers coming in and taking that away from them. So,
thank you.
Thank you.
Yes.
Hello, council members. Good morning. Elizabeth Ghanem Ham on behalf of 70 Acres, 180 Land, and 4 Stars. I just want to start by commenting that although your staff has had the inability or unwillingness to do the research as to what properties are impacted, these 300 properties that were listed, we certainly have. Of the 300 properties, all of them are either owned by the city or by the HOA and accounted for by the CC&Rs. So this is selective enforcement. Selective enforcement is a violation of the Equal Protection Clause, as it makes this ordinance a class of 1. It is exclusive because it is targeted at a specific owner, specific landowner, and it carries with it selective enforcement. Both of those things violate the Nevada and U.S. Constitution. Additionally, as you continue to narrow this, it becomes more and more clear that this is aimed at Badlands, which makes it unconstitutional. Section G, what I heard today, and that's the maintenance closure plan, is that it in fact will be retroactive. That's what I understood the explanation to be. It is 4 pages of what a landowner needs to do. It is restrictive and it encumbers the property, and it is a violation of the ex post facto clause, which forbids passage of laws that carry with it punishment. This passage of this ordinance will be met with legal action, and I want to make clear that while you continue to mark that there will be no fiscal impact for the city, there surely will be. We will challenge any ordinance that takes away our constitutional land rights.
Thank you, ma'am.
Thank you.
Okay. Whoever wants to come up, right or left?
Tommy White, Laborers Local 872, also my home residence is 8225 Old Cistern Court. We wish that you deny this ordinance. You know, this is kind of restricting building for us. We live on building, we live on on developing, and to watch something like this, where we're going to start telling developers we're going to put them in jail if they don't adhere to a law that's going to try to be put in place. As the young lady said before us, we will be partnering up with anyone that's going to have a lawsuit against this bill, because we feel that anyone that wants to stop us from building, we're going to have to take a stand with it. As far as part of the bill saying the maintenance, should this maintenance of the golf course is going to wind up with the city, with all due respect to the city employees, they can't maintain the parks they have now. So throwing this back onto the city and allowing the city to pick up a maintenance on something that's already been, I mean, if you look going all the way back to 1996, the developer has the option to build on this piece of property. And we wish that you deny this ordinance.
Thank you, and we have your letter, Mr. White.
Good morning. I'm Johan Lowy, the owner of the Bedland Golf Course. First thing I want to put on the record that we do not believe this ordinance applies to us. We know that
Just
the city
speak a
trying to make it.
little bit closer, Johan, so we can hear
Yes.
you. Yeah, thanks.
I'd like to say first that we believe that the ordinance is not applied to us because we're neither an open space, no closed golf course. But I know the city wrote this ordinance specifically toward to shut down any development and continue the extortionary measures of Councilman Coffin and his co-racketeers, Frank Schreck, Jack Binion, and others. And we intend to take it to court. Also, Mr. Coffin, you just said a few minutes ago, on the record, you say that we decided to close the golf course, and it was up to us. Have you ever looked at the design standard and the condition of approval of the golf course? Have you read them?
Johan, hold on. We're not here to debate. We just want to hear what you're for or against the ordinance. So if you want to have a debate with Councilman Coffin, we can do that later.
Chairman,
Just tell us.
Mr. Coffin should not have made the comments and asked questions about lenders, who the lender is. I know you want to interfere with the lending, and you have much more problem coming from the lender that you have from me. So stay tuned, and you'll get the brunt of it pretty soon. But I want to, again, since he opened it to a public meeting and he asked questions, I have a right to respond to these questions and ask him a question. Did you ever read the condition of approval for the golf course?
I am not here to answer your questions, Mr. Lowe.
Good.
Let me ask you one in trade, okay?
Okay, we're getting...
You've sued a lot of people that live there. You've sued residents that live there who oppose.
We're way
Are you going
up.
to sue any of the people who have protested, who live there?
Okay.
I'm going to sue anybody that interfere with my rights to develop the property and continue and put them into this,
Johan.
Okay,
See, that-
fine, yeah, I got it.
That's why you get in trouble at meetings.
I got it. Let me just finish. I will put my thing on the record, so I
30
understand.
seconds to finish whether you are for or against the ordinance,
Yes,
okay?
no councilman have read the condition of approval.
Okay.
I want to make,
Are you for or
including
against,
yourself.
are you for or against the ordinance?
Yeah, Your Honor, you let people here speak for 15 minutes from the other side, 10 minutes.
you're not talking about
I
the
said I'm
ordinance.
against the ordinance. I said
Okay.
it's an extortionary measure
Very good.
that intended specifically to pray this piece of property from us that we intend to
Okay.
hold for many years to come. I want to say something to you so you get it to your head. This was never a golf course. It was never approved as a golf course. You don't have any land use for a golf course, and it never went to an SDR. It was nothing but RPD 7. These homeowners here that are opposing here, getting the letters from Shreks to send to everybody on the council, they're opposing to it, knew exactly what it is they bought into it. And now you're asking to change my backyard landscaping, for that matter, and make a penalties on backyard landscaping and put me in jail. I will go to jail, but when I come out of jail, believe me, there'll be a lot of
Okay.
hell to pay for.
Thank you, Johan, appreciate it.
I'm not going to argue.
Greg, why don't you come on up here?
I don't
we're
know
good.
what I did play for 20 or 30
That's okay.
rounds if it wasn't a golf course.
Let's continue on. We're having good public comment here.
That was a golf course I played a number of times, I swear, Mr. Chairman.
Very good.
If it wasn't, I don't know what it is that he destroyed.
All right, Bob, thank you. All right, go right ahead.
I'm not going to be anywhere near as exciting as that.
No, you're fine.
Greg Esposito, 760 North Lamb, representing the Plumbers and Pipefitters Local 525, but also the Southern Nevada Building and Construction Trades Council, which, because they're in the room, I have to be very clear, does not represent the carpenter, or is not affiliated with the carpenters or the laborers. We represent the other building trades unions. And we agree with Mr. White and a couple of the other people who testified about jobs and job creation. We understand that developing this property would create jobs, and of course, we're always in favor of that, if it's intelligent growth. We are in favor of the ordinance, not all the details and not all the problems with it, because it sounds like, for the past hour, there's been a lot of problems. But our members are the ones who live on those golf courses and on those green spaces, and they deserve protections for their investment. While we do appreciate jobs, we work to live, we don't live to work. And so as we earn our money, we buy investment properties, we buy homes to raise our families and grow our fortune. And if those property values are then diminished through bad development that does not meet community standards or does not benefit the community, that doesn't serve our ultimate goal, which is building a community. We've opposed wind farms in ecological sensitive areas. We've opposed solar farms in areas that they don't belong, fracking. We believe in jobs, and we want them, but not a temporary 9-month to 1-year job at the expense of the value of someone's home. So we're in favor of the ordinance in how it protects homeowners, but understand that there seems to be a lot of problems with the language. So we're not speaking on that, just speaking on how we'd like to make sure our members stay protected.
Thanks for coming down. Appreciate it. Yes, ma'am.
Hi. Good morning still. My name's Colleen Mullaney, M-A-L-A-N-Y. I'm from 8617 Echo Grande Drive in the Silverstone community. And I just, I'm basically just reiterating that we would love to see the abeyance happen because there's some nebulous language in here that needs to be changed. Stronger language instead of saying might or suggest in those terms. There's golf course and open space are interchanged, and I believe that they shouldn't be able to be interchanged. They're totally different, as well as what is the definition of repurposing. What just transpired, I think, is just a perfect example of why we do need some kind of ordinance. Developers need some reasonable restrictions. Otherwise, I feel like it could be a precursor to a fraud. So we do need something, but as it is right now, I think we need to work on it.
Thank you.
Thank you.
Yes, ma'am.
Thank you. I have a quick question before I say my piece. At the back of this ordinance, there's a letter in there. So it's input it says for the record for the backup of this meeting. So we sent in emails as well. So I was just curious as to what ends up being on the record, or why there's some that's part of this, but others that are not.
Luann can answer that for us.
Good morning, Luann Holmes, City Clerk. All the emails that we received over the last week will be submitted as part of the record, and so it will not be scanned and put online until probably near the end of this week. But going forward, if this bill goes forward to council, you'll see your emails as part of the record.
Oh, I'm sorry?
Okay.
Okay, you got
Thank
okay.
you. Go right ahead.
Process
did you
question.
state your name?
I'm sorry. Ann Smith, 653 Revelle Court, Queensridge.
Hope you're not sued. Are you being sued?
We've had letters, but haven't been served.
Go ahead.
Been threatened? Thank you.
Are
We've
you
been
for or
threatened.
against the ordinance, and tell us why?
Okay. So I just want to say that I appreciate that you're hearing all these points of view here. And although, people are saying against or for, I think the underlying, need out of this is common. So I don't see that this can't be handled with this ordinance. So the underlying need is we all want a good quality of life, whether it's through getting jobs for this developing, or for maintaining your quality of life if you're affected by it. So it seems like we all have the same underlying need out of this, and that this ordinance is something that could provide that. It's a process, and rather than being reactive to what's happened on 2 golf courses so far, then you get to be proactive. And it seems like this ordinance has worked elsewhere in the country, so it seems like that would help. I think really the city's ordinances need to keep up with the changing times. So because these things keep coming up and it's new, then ordinances have to be done to take those into account. And so I'd urge you to support this and recommend it to go forward for passage. And even though it's not perfect, you amend ordinances all the time. So it seems to me something needs to be on the books before the next one comes in for you to review and take care of. Thank you.
Anyone else? Come on up. If there's more people, come on down.
Steve Carrier, 9101 Alta Drive. I'd like to make a couple of statements. First, I'm personally offended at the attacks of the council members. Councilmember Coffin, Shiroka, and others that have been attacked as they've tried to do their job. Just because someone doesn't agree with someone else's opinion doesn't give anybody else the right to attack our council members that give their time, their energy, and their effort, and they deserve the respect that should come with that. The second thing is that this should not be a conversation about Badlands. However, it has become one, because many people have come up and represented issues. But I will tell you, as being someone that's been involved in development both nationally and internationally, what I can tell you is developers don't go forward without entitlements. As far as I know, there were no entitlements issued prior to the purchase of this land.
Steve, we really need you to focus on what
I understand, but all these other people address the same issue.
Okay.
And I'm just trying to say, when Attorney Newman says that the owner would be valueless, he should have thought of that before he purchased the property, because that's what developers do. They know what they're getting into. So I'm in favor of transparency. I'm in favor of the bill. I'm in favor of government providing guidelines. So instead of this being a 3.5-year process, as someone said it would take 1.5 years to get through this, it would have saved 2 years because it gave a process to work through. So I'm totally in favor of the ordinance. Thank you.
Thank you, sir. Yes, come on up.
My name is Terry Holden. I live at 9101 Alta Drive. I'm definitely in favor of the ordinance. I think we need the structure that's provided in. I think it's well thought out. There may be a few hiccups, but I think for the most part it's well thought out. Developers may think it's tough, but it isn't. You know, I grew up in Oregon, did development there. This is not a tough bill by standards in other parts of the country. And again, I'm in favor of it. And how has it worked so far? This is not a Badlands discussion, but how has that gone? 3.5 years later, meetings until 1:30 at night. We made no progress on either side. There's litigation. How has that worked? So I think we're in desperate need of some structure, some guidelines, and I think this bill provides it.
Thank you, sir. Thank you.
My name is Chris Evans. I live at 10824 Windrose Point Avenue, Las Vegas, Nevada, 89144. I'm here to speak in favor of the ordinance. My views are colored by a past as a real estate developer in Southern California and also as a resident here. I think the more information that the City Council has in reviewing projects and developments, and the more stakeholders that are brought together to have active discourse and dialogue would be an improvement for the community and for the city at large. And for those reasons and for the reasons Councilman Soroka brought up earlier this morning, I'm in favor of it. Thank you.
Thank you, sir. Okay, that's it. All right, I will close public hearing, so I'll see if anybody has any discussion or motions up here.
I move for a motion to obey for 45 days as my Silverstone members have come up and spoke. The ordinance, they would like to, we need to work out the kinks. Also for the record, since I'm very dedicated to this, I downloaded Title 19 stuff. from the Planning Department's website this weekend and searched through all 595 pages. And the word misdemeanor only shows up 6 times, and I've provided those 6 pages for the record. Not once in Title 19 does it mention jail time. So with that, I'm going to motion to obey this for 45 days so me and my constituents can have a big powwow.
Okay, so before we vote, let me just get the dates down for everybody. So Luann, what would be the date of recommending?
October 15th.
October 15th, and it would go to what city council?
November 7th?
November 7th, okay. All right, October 15th. So I'm going to support the motion, but we're gonna have to vote on this October 15th. We can't keep kicking this down the road. So I plan on having an up or down vote on October 15th, and this will go to the city council for a final vote on September 7th, November 7th, so we can vote this up or down and move on to other things. So, okay, all those in favor, so we're going doing this electronically because I was reminded, so go ahead and vote.
On the motion, if I could say,
Go
I'll be
ahead.
opposing the motion, but the reason is because these homeowners, not just in that area of the Queens Ridge development, but all others are hanging on this because anybody could intervene at any moment, recognizing that there is a critical move time for them. And before the October meeting, before the late October meeting, you'd have a situation where anybody could then come in under the old rule. And I think it's time for the council to take a stand on this, to support those neighbors in Silverstone and anywhere else that, you know, needs to have a say and have some protection, because it is one of those things where some members, this one included, have been accused of extortion today by a developer.
Bob, you misread that. Stop saying things like that on the record.
Excuse me, I have the floor. You learned the rules in the legislature, so don't interrupt. If you have such charges flying around, can you imagine what they'll be like in 45 days? So I will speak against this motion, therefore I am now going to shut up and let you vote for it.
Okay, let's vote. Let's vote and let's post. Go ahead and vote. Okay, motion carries. So those are the dates. Just as a reminder, because Stephanie Allen mentioned it, obviously anybody who spoke today, public comment, you're on the record the way you spoke. On October 5th at recommending, I'm dyslexic today. October 15th, we'll have this recommending. There'll be public comment again. Anybody who wants to come down and make public comment on the ordinance again, you can do that, or whatever you said today is on the record. On November 7th at the City Council meeting, normally we do not have public comment for ordinances and their vote at a City Council meeting. We just go ahead and make a motion and vote, but it's up to the mayor whether she wants to have more public comment on November 7th at the City Council meeting. So that's how all the public comment works. So I'm hoping October 15th we'll vote here, November 7th we'll vote this thing up or down. So thank you very much. I appreciate everybody coming down. It was very good public comment. So let's go on to item number 5. Bill number 2018-36 for possible action, annexation number 73495, property location on the west side of Egan Crest Drive, approximately 335 feet south of Ann Road, petitioned by Upgrowth NV Partners. This is sponsored by Councilwoman Fiore. Mr. Summerfield.
Mr. Chairman, so the proposed ordinance would annex a certain real property generally located on the west side of Egan Crest Drive, approximately 335 feet south of Ann Road. This annexation request is at the request of the property owner. The annexation process is now completed, has now been completed in accordance with NRS, and the final date of the annexation is anticipated October 12th, 2018, as set by this ordinance. Everything else is in order if there are any questions.
All right, any discussion up here, or do I have a motion?
Motion to approve?
Okay, go ahead and vote.
Are we electronic?
And post. Motion carries unanimously. Thank you. All right, item number 6, bill number 2018-37 for possible action, grants to MC Metro Access Transmission Services, a non-exclusive franchise for the purpose of installing, operating, maintaining a telecommunications service within cities, subject to and according with the terms and conditions of the franchise agreement incorporated by reference in this ordinance. This is proposed by Jorge Cervantes, Chief of Operations, and our Development Officer.
Good afternoon. I'm Gina Bishop, Franchise Analyst, Finance Department, the city. This ordinance would grant a franchise to MCI Metro Transmission Services to provide telecommunication services in and throughout the city of Las Vegas.
Okay, and you're recommending approval, obviously.
Yes, I am.
Okay. Any discussion or questions up here? Do I have a motion?
Motion to approve?
All right, thank you. Go ahead and vote. And post. Motion carries unanimously. All right, we're on item number 7. Possible action amends LVMC Title 10 to add a new chapter regulating the possession of certain items at public protests, demonstrations, rallies, picket lines, and public assemblies, sponsored by me, Councilman Stavros Anthony. Hi.
Good morning, or afternoon now. Tim Schattler, City of Las Vegas Department of Public Safety. And we were approached by Las Vegas Metropolitan Police Department just after this passed the County Commission back in June unanimously. They worked closely with the Culinary Unit and the Culinary Union and the ACLU to draft this ordinance, and so we're just mirroring it to have it a like ordinance on the city books.
Okay. All right. Public comment. Anybody from the public wishing to be heard on this item?
They're running.
Oh, I think they wanted me to make one announcement. Do you want me to, is that what you wanted?
That's fine.
Okay.
Thank you, Mr. Chairman, members of the council. My name is Chuck Calloway. I'm the Director of Intergovernmental Services for Las Vegas Metropolitan Police Department, and we want to thank your Department of Public Safety for helping us bring this before you so that we have a consistent ordinance in both the city and the county. The only thing I wanted to put on the record is that having talked to the folks both at the Culinary Union and union folks here today, that the intent of this ordinance is that it does not apply to floats. That was something the ACLU wanted to make sure, and also not static displays. So your static type displays would not be subject to this. It's specifically intended for the folks' signs that would be carried in your hands and people showing up with sticks and bats and those types of things. Like you see, if you have the presentation, the first couple slides that are in there that show like what we saw in Charlottesville, people showing up armed to do combat. They're not there for the purposes of expressing their First Amendment rights. And then the officer would, we've trained our officers already on this ordinance, how to deal with it, and basically the intent is to give a warning if someone were to show up with a shield and the sticks and bats and helmets to a protest. We would ask them to leave, to put that stuff in their car and return without it, and then if they refused, the officer could cite that person or take appropriate action. Only in extreme cases where there was an emergency would we enforce on the front end with an arrest or something of that nature. So that's the intent.
Okay, and you did a PowerPoint. I have.
Yes, I believe it was submitted to the.
You have this, Luann?
To the council.
PowerPoint? No. Here, you can have mine. Or
yeah, you. Yeah, this is what they gave.
There's a bunch of good stuff in here about.
That's
it talks about increase in violence, professional protesters, Las Vegas is a location for public gatherings. It talks about all the stuff that's prohibited, couple of 3 pages on that, which is all in the ordinance. Again, there's a page on here on your floats and static displays you brought up. There's 1 page on canes, so if somebody has a cane and disabled.
Does not apply to any items needed to gain access to the.
Right. Okay.
And I should make mention for the record that in working with the Culinary specifically Mr. Papa George and also their general counsel. That's how we came to the specific dimensions for stick sizes that are in this, to not interfere with the banners and signs that they currently carry in their labor protests.
Okay, and I have a lot of confidence in the police officers out there who have the training to know when to cite and when to take somebody to jail and why. They know what they're doing. They know how to enforce this.
The whole goal here is prevention, so we don't get into a Charlottesville type situation where we can prevent something like that and ensure people have a right to protest peacefully.
Okay, any questions up here?
Just a real quick one. Oh, I'm sorry. Go ahead. If you had one.
So I just want to, as you were going over this bill on specific items, especially what's happening countrywide, it's important to, on the record, talk about any projectile launcher, wrist rocket, catapult, weapons such as knives over 3-inch blade, box cutters, ice picks, axe, taser, stun gun, nunchucks, pellet gun, not firearms, bottles or balloons filled with any flammable, biohazard, or noxious matter in the intent to throw, disperse, flame torches, lanterns, excluding candles. I mean, looking at that, people showing up with, launchers, it's obviously not a protest. So just wanted to make sure that was clear.
Yes, and for the record also, Chuck Calloway again, obviously, as you well know, this has nothing to do with firearms. That's something that the state legislature has preemption on, and it's not our attempt to impact open carry laws or anything like that. We did make a lot of concessions in the language. For example, there was concern about folks that carry pocket knives for purposes of cut and string and that type of thing, and that's where we came to the 3-inch language. Also at the county commission, Chairman Sislak brought up that sometimes at some of these protests or rallies, they shoot T-shirts out of a launcher-type device, and the intent was not to capture that, so that language was put in there. So there was a lot of work that went into this at the county to make sure that everyone was in agreement, all stakeholders were in agreement. We appreciate any support.
Thanks.
Thank you.
Councilman Coughlin.
Thank you. Just wanted to make sure the dimensions of wood, or I guess stuff to hold up a stick, whether it's wood or plastic or metal, well, you have dimensions on the width and the thickness, so they don't have a lot of mass. And is there any limit on the length?
No, we didn't put a specific limit on the length.
Okay. And then also the question is paragraph 6 on page 2 just really begs the question, aren't we just saying something pretty silly when we say it's okay to bring out toy guns? Why do we have to say that? Because it makes us look like such hypocrites, because we're not saying you can't take out a loaded firearm.
Yeah, and I think that, again, Mr. Chairman, through you to Councilman Coughlin, I think the intent was to, in some places, for example, people may show up to protest in costumes, and the intent was not to take away, somebody's ability to peacefully protest. The intent was for us to stop someone from showing up with, sticks. Obviously, like the pictures you see in that presentation, they're armed for fighting. They're not, like Councilwoman Fiore said, they're showing up not to protest peacefully, but to cause problems.
Just because I want to make sure we don't have somebody arrested by accident or person get away by accident. So they could carry a firearm if they have a permit or concealed. Oh, no, I'm sorry. If it's an open carry, they could carry it outside their cloak or whatever it is they might be wearing.
This,
right?
yes, Mr. Chairman, through you to Councilman Coughlin. So nothing in this ordinance impacts state law regarding firearms. So if you are a valid CCW permit holder, you could carry your CCW firearm. If you open carried, you could open carry. Unless obviously the protest was in one of those exempted places, like for example a school. Nothing in here impacts firearm laws for the state. So as long as you're abiding by state firearm laws, you would be okay.
Okay, so but you could wear, if you had a concealed permit, then you could wear it under your costume.
Yes, if you're and I'm keeping in mind again not to get into the firearm realm, but theoretically, a CCW permit holder has undergone a background check. They've gone through training. They've received firearms qualification in order to be able to be licensed under the state CCW laws to carry that firearm.
How would we know, if I could continue, how would the officers know if somebody has a CCW permit, they think they know, or they think they've got a weapon under their costume, are they allowed to ask, if they see a bulge, for example, are they allowed to then ask them to see their CCW permit?
Mr. Chairman, through you to Councilman Coffin, we train our officers in constitutional law, so they're trained on how to approach those types of situations. But specifically, it would depend on the situation. But let's say hypothetically we had a protest occurring and someone had a jacket or costume or whatnot on, and their shirt lifted, and the officer saw a firearm, and the officer felt that that might be a threat to other people there at the protest. The officer might approach that person and say, hey, excuse me, sir, but it appears you're in possession of a firearm. And then on the other side of the coin, CCW permit holders are trained when they go through their classes and their training to always let an officer know when they're encountered by a police officer that I'm a CCW permit holder, I'm in possession of my firearm, here's my card that shows I'm a holder. And we have the ability to verify that through our dispatch section, so the officer could verify that information. But again, it's a case by case, every situation's different. I can't stand here today and tell you that every single scenario would be handled the same exact way.
Well, can a person carry a rifle of any length?
Yes. Open carry.
Open carry only,
Yes.
cannot be concealed?
No, unless they have CCW permit only applies to handguns. So,
Okay.
so they could carry a rifle open carry, but not concealed.
Okay, I know that we apparently don't have any rights to regulate anyway firearms at the local level due to the legislation from a couple of sessions ago.
That's correct. Senate Bill 175, I believe, Senator Roberson's
Senator Roberson.
bill.
Yeah.
Yes.
Okay. All right, thank you.
All right.
You can regulate toys, though, by God.
Motion to approve?
Thank you.
Thank you. Appreciate it. Thank you.
Thank you.
And opposed? Thank you.
Them toys.
All right, motion carries. By the way, everything that we've passed so far is eligible for the October 3rd City Council meeting. All right, we're on item number 8, which is 2018-39 for possible action, amends LVMC Title 19 signage within the Las Vegas Boulevard Scenic Byway Overlay District from the general limitations on animated signage that prohibit full motion video, sponsored by Councilman Coffin.
Mr. Chairman, this bill will make an exception within the Las Vegas Boulevard Scenic Byway that will allow LED signs, changeable message unit signs, to be able to show full motion video, where currently all images that must be static and they must maintain the image for a certain period of time, and then they must transition directly to a new image. They can't do any kind of, PowerPoint-like animation where they fade in or do any of that kind of stuff. This will provide an exemption within the Scenic Byway that will allow more flexibility in how messaging is delivered on those changeable message units.
All right, any questions? Oh, I'm sorry, public comment? Thanks for standing up.
Good morning, or good afternoon. My name is Michelle Laramie. I'm with Nevada Preservation Foundation. Our office is located at 330 West Washington Avenue, Suite 106, in 89106. So we're just here today, I'm here today representing Nevada Preservation Foundation to express a few concerns over the proposed amendment that we have. And while we understand that there is likely a need for greater flexibility on signage in the corridor, we do believe that the proposed amendment will likely have some negative and inadvertent consequences on the scenic byway that I'd like to talk about. First, I'd just like to start by calling attention to Vision 45, the plan that was put together through significant community input and outreach, which does call out the scenic byway as an important cultural feature for Las Vegas. Specifically, it recommends two treatments for the scenic byway, and the first is to treat it as a key unifying element of the downtown core, taking measures to enhance its scenic qualities, and the second is to continue to encourage the protection and exhibition of neon signage along Las Vegas Boulevard to enhance its historic and nighttime scenic qualities. So with those in mind, we specifically see the following possible consequences resulting from the proposed change, and that is allowing video signage will de-incentivize the restoration of neon in the corridor. Allowing video signage will also overwhelm existing neon signage and the like in the corridor, which existing business owners have already invested in and followed. And that neon video signage will significantly alter the existing character and identity of the byway, creating an environment that is no longer cohesive and will be undesirable for tourists and residents alike. But with those consequences said, we do again understand that our environment and economy is an ever-changing thing, and we're not specifically opposed to a sign amendment. We would just like to see some compromise. And some of those compromises may be that allowing video would only be allowed in combination with other static lighted elements to further encourage the restoration of neon. That perhaps the percentage of neon that's currently required could be reduced, and that the video signage would not count towards this reduced requirement of neon. And that there be some design guidelines perhaps introduced for video content, so that any video content that is introduced into the corridor would have the same artistic qualities as the existing neon signage and would contribute to the existing cultural character rather than deter from it. So with that said, I'll just wrap up. I don't want to take much more of your time this morning, so I would just ask that you carefully consider the proposed changes going forward and perhaps consider some of these compromises. I know there's additional compromises that have been submitted both at Planning Commission and also by the Historic Preservation Commission. So I would ask that all of that be reviewed and taken into consideration before moving the amendment forward as written right now. Thank you.
So,
okay, let me just see, is there any other public comment? Okay, so, yes.
Ms. Michelle, Councilman Coffin, do you have those amendments? Because you don't have them. Because in downtown with the historical preservation, because I know we're working with you guys in our ward too to make sure are you open to this?
No, not on this bill. Let me explain. I will explain. If you're asking me a question, so the only applicable place is Vegas Boulevard because it's a slow speed street. That one of the things we have considered is there risk to driver safety and pedestrian safety. So this only applies to a slow speed street, and of course not arterials, not freeways. So they have to stay with the same kind of pattern of the 6 or 7 second maximum exposure, minimum, or I should say minimum exposure of a frame. And then I've worked with all of the people who have these signs. They've invested a lot of money in them, and they are wrapping them in neon. Now, I don't want to get into specific percentages now because that's just something that I haven't seen. I haven't had a chance to absorb, talk to those people who have already invested a lot of money down there. And so I'd hesitate to say, whatever they're saying could be reasonable, but it's a little late in the game to present that. When does this come to council, Mr. Chair?
October 3rd.
Yeah, okay.
So I'll work with them. I'll work with them with the Preservation Foundation and see if what they want.
My concern is, in the historical downtown, is all of our beautiful historical signs might get drowned out by these video footages, especially on Las Vegas Boulevard when we have the porn places. I don't want to drive down Las Vegas Boulevard and see naked girls on a video sign.
You don't have to, they're walking.
Bob, like for real? Like, I just want to make sure with this ordinance, you're cautious of not ruining our historical preservation for downtown with nakedness.
Are you amiable to ban this just to get them a chance to talk to you personally about it?
If nudity is the main concern, we have a problem with
the whole
sign.
thing, everything that she mentioned, at least, I think it'd be a good opportunity for her to at least sit down with you.
Let's obey it to our next meeting.
When's the next meeting?
October 1st.
Okay,
October 1?
so-
Sure.
I'm gonna.
I move for
you want-
approval. I move to obey.
Okay,
this
so we
bill until
have a
October 1.
motion to obey this to the October 1st recommending committee.
Thank you.
And post, all right, there you go. Thanks for coming down. All right, we're on to item number 9, bill number 2018-40 for possible action amends LVMC 13 regarding obstructions on public right-of-ways to include additional means by which obstructions may be permitted and to clarify that the term obstruction includes certain conveyances made available for use commercially, proposed by City Attorney Jerbick. Who's going to comment on this?
I'll make this presentation.
Thank you.
Mr. Jervik requested this bill. The main focus of it is to include within the definition of obstruction, which triggers a lot of remedies under our public streets and public rights-of-way code, to treat as obstructions scooters, bikes, kind of the dockless kind that can end up on rights-of-way. It wasn't clear in our code that that could be an obstruction because it's a mobile device, and a lot of communities have experienced these vehicles, if you want to call them that, these conveyances being left on the right-of-way. Somebody rents one, drops it off, and we certainly have a desire to establish a framework for those, whether it's by a code chapter or doing it by franchise, but right now we don't want them being put on the sidewalk before we have that regulatory or franchise framework in place. So this would add to the definition of obstructions those kinds of conveyances. And then the other thing it does is it conforms our obstruction code, something that's been in the works for some time, to align with the actual practices of the Department of Public Works and Building of Safety. So we recommend approval.
So, just to be clear, Val, this doesn't authorize that we approve bicycles and scooters and stuff in a certain area. It just
right. It says that those things that are left there are an obstruction and can be given public notice and then removed, and held for someone to come pick up if they end up burdening our rights-of-way until we can get something in place.
Okay, great.
Just a minute. I have a question, ma'am. May I?
Yeah.
So in essence, by reference, does this then approve the use of things like bicycles and scooters on the rights-of-way or anywhere?
It only talks about things that are abandoned.
Here's a problem with a lot of these right now that are being abandoned. They look like they're abandoned. It's being proposed that we have Lime and a few other scooters and bikes that you could then leave, and another person who's interested in using it on the sidewalk could then pick it up, sign in with the app, and use it. But that looks like abandoned to me.
So Jorge is working on this, and there's moving parts to it. So I'm going to defer to Jorge and what he wants to do. I'm with you, but I'm going to go with our staff.
For the record, Jorge Cervantes, Chief Operations Development Officer. Councilman, the City Attorney's Office said this really just creates a definition of what obstruction is, so that if a obstruction, a scooter, is left in right-of-way, we have the ability for it to be removed by giving notice or through our staff. Separate to that and concurrent with that, we are working on a pilot program that you'll be briefed on this afternoon during briefing. We briefed this morning on it, where we're going to do a pilot program with Lime to try it out for 90 days, a 3-month pilot program. But we need this in order to be able to enforce the regulations that if it is left in the way of pedestrian, we have the ability to move it out of the way.
Mr. Chair, I've visited with the Lime representatives, and I have said that we do not want them downtown in Ward 3. And the reason is because they will be abandoned. They will be left behind. And how do you define what is abandoned? How long does it have to sit there? And then what do we have to do, give notice in writing? I mean, in essence, that's where you're going with this. You give notice, it's in writing.
Councilman, we're entering into a contract with these folks for that pilot period. In there specifies exactly how long they have to respond. If they're given notice that it's obstruction, what the time frame is, and if they don't respond, we have the ability through our crews to confiscate it and take it away.
Who is going to enter into a contract city staff or the council?
No, it's administrative, it's the city staff, it's an agreement, it's a contract between, it's a 90 pilot program between the vendor and the city.
Without bringing it to the city council?
That's why we're briefing this afternoon.
Yeah.
Well,
So, Chair.
that's not.
So I motion to approve.
Absolutely crazy.
All right, we have a
I don't
motion.
think so.
We have a motion to approve. Any more discussion on the motion? All those in favor, go ahead and vote.
Not workable.
Okay, motion passes. This will be heard at the September 5th City Council meeting. And item number 10 is citizen participation. Anybody from the citizens who would like to comment on anything?
I'd like to take a comment time.
Okay, go right ahead.
Thank you. Since no one is up here, I'll take their time. It's a matter of interest that the proponent of a development here in town would threaten a member of the council. Of course, legal action, which means stifling the voice of the people as elected by the people. But also, when an advocate for a position threatens people who are in opposition, ordinary citizens, as he said on the record, that he would sue people who are opposed. You know, that's one thing. And I think that fortunately, like Ms. Smith, who said she'd been threatened, Ann Smith, but had not been sued yet. But others have been sued. I talked to 2 people today who have been sued by that guy. So I can take a lawsuit against me anytime, because as crazy as they are, it's one of, it comes with the job. But when you say, as the developer did, I'm not your biggest problem, the lender is, that's a threat. And I need to know from legal counsel if we can identify who the lender is other than Vegas Ventures LLC. I think it's Vegas Ventures LLC is the name. So I would like to know what we can do to find out who that is.
I think you should have a private conversation with our attorneys.
Well, it's on the record, though.
Okay, very good.
Thank you.
All right, looks like we're adjourned. Thank you very much. We'll see you next time.